Good evening, everyone. I'm Kimberly Apollo, President of the California Judges Association, and we're extremely grateful that you have taken time from your busy schedules to engage in tonight's conversation about the courts, how judges work, and the judiciary's unwavering commitment to applying the rule of law. This town hall is organized by the Judicial Fairness Coalition of the California Judges Association. The mission of the coalition is to provide transparency about the courts and demystify the judiciary so that you are fully informed about the special role that this branch plays in government and our free and democratic society. Never in our lifetimes has there been so much public interest in the workings of government, nor as pressing a need for the public to understand the roles, the responsibilities, and limitations of the executive, legislative, and judicial branches. And never in our careers as judges have we realized a greater need to hear from you with your thoughts and questions about the work that we're so impassioned about and committed to. A wise woman who was the president of Kosovo once shared some words of wisdom, and she told us that democracy must be built through open societies that share information. And when there's information, there is enlightenment. And this is exactly what we hope to achieve with tonight's event: a contribution to maintaining a strong democracy, an open sharing of information that we hope you find enlightening about the branch, as I know we're enlightened by your questions and comments to us. Tonight's presentation is designed for members of the general public to learn more about the judicial branch. We are very happy to have a number of people here from the legal profession and the legal community, but this program is not intended to expand the knowledge of lawyers or judges. It focuses exclusively on state government and features state court judges and practitioners. We received many questions about the federal government, which we can't answer directly, but I do want to note for you that state and federal systems are very similar in structure and operation. So most of what you're going to hear today about state courts will apply federally. I do want to thank our collaborators on this program. That would be the California Lawyers Association, California Lawyers Foundation, the American Board of Trial Advocates, also known as ABOTA, McGeorge Law School, the Los Angeles County Bar, the San Diego County Bar, and you, all of our presenters and everybody who's participating tonight. We thank you for your comments and questions, and we're really looking forward to talking with you. So now I'm going to turn over the program to our esteemed moderator, Attorney Oliver Dunlap. He's a San Francisco attorney with the law firm of Barco Pavia. Oliver?
Thanks very much, Judge. I'm very delighted to be able to be here tonight with our esteemed panel. And I want to give some quick introductions for who is going to be presenting with me tonight. First off, we have Justice Tracy Brown. She's the presiding justice of Division 4 of the First District Court of Appeals for the state of California. She was appointed by Governor Newsom and confirmed on April 7th, 2023. Prior to her appointment as presiding justice, Justice Brown had served as an associate justice with Division 4 since 2018. And prior to joining the Court of Appeal, Justice Brown served for 5 years on the San Francisco Superior Court, where she heard criminal cases and where she served on the court's executive committee. Justice Brown is a Phi Beta Kappa and magna cum laude graduate of Harvard. She also worked in Japan for a year before obtaining her JD from UC Berkeley School of Law in 1996. After law school, Justice Brown clerked for Judge McCown on the Ninth Circuit Federal Court of Appeals and worked for several private law firms before joining the U.S. Attorney's Office in the Northern District of California in 2002. Justice Brown has received numerous awards and accolades throughout her career, including the 2002 Jack Berman Award for Distinguished Service to the Profession and Public from the State Bar, the Joe Morozumi Award for Exceptional Legal Advocacy from the Asian American Bar Association, and the United States Department of Justice's Director's Award. She's a guest lecturer at Stanford, the University of San Francisco School of Law, and the UC Law San Francisco. One quick note, Justice Brown has got a prior commitment, so when we get into the Q&A session, which is very much going to be a focus later on, we've got a presentation for you, but then we really want to do some interaction. Justice Brown may need to leave a tad early during the Q&A session. Our second presenter tonight is Judge Patrick Thompson. Judge Thompson served as a judge on the San Francisco Superior Court since March of 2022, where he handles criminal cases. He was also appointed by Governor Newsom and in 2024, he won re-election outright in the primary. Judge Thompson received his law degree from Harvard, having obtained his undergraduate degree from the University of Michigan. He was inspired to enter the law as a child when he learned about the profession's intellectual challenges from a mentor. Prior to joining the court, Judge Thompson was a partner at Perkins Coie LLP, which he joined in 2015, and where he served as the lead of its San Francisco litigation group. He had previously been a partner at Goodwin Procter from 2005 to 2015, and a partner and associate at Pillsbury Winthrop Shaw and Pittman from 1992 to 2005, where he had been the chair of the National Antitrust Practice. He chaired the board of Grace Cathedral and California Pacific Medical Center and served as a longtime trustee of the American Conservatory Theater here in San Francisco. Our third and final presenter is going to be retired Judge Arthur Wick. Judge Wick was a judge for the Sonoma County Superior Court until 2023, having spent more than 45 years in the courtroom. Judge Wick served as an attorney for the school and college districts throughout California before being appointed to the Superior Court by Governor Schwarzenegger in 2006. Judge Wick earned his Bachelor of Science degree from Cal State Long Beach and his law degree from Northrop University. He also attended medical school at USC, who had a program for practicing attorneys. Judge Wick spearheaded the creation of the town of Windsor, co-chaired the committee to create the Windsor Unified School District, and chaired the successful bond campaign to raise $28.5 million for the Windsor Unified School District. He served as the president of the Sonoma County Bar Association and as the supervising judge of the court's civil division. He also sat on the executive board of the California Judges Association and served as president of the California Judges Foundation, and has sat as a pro tem justice on the First District Court of Appeal. I apologize for a longer introduction, but as you can see, we've got a very esteemed panel. I know many judges, and they are all extremely dedicated public servants. As you can see, a significant amount of experience, so I hope really are going to be able to answer some of the questions that you have for us today. Let me cover some basic ground rules for how this is going to work. First off, we are recording this session. I want to make sure everyone knows that we are recording. That said, all the participants in this program, except for the panelists, those of us here, and the moderators, myself, are going to be off camera and muted. So we're running this like a webinar. This is because we have over 120 people viewing this and registered as part of the conversation, and we want to make sure that all the panelists can be seen and heard as we're presenting. Additionally, we really want to get questions from you, and we want to make sure that everyone feels comfortable asking questions without any concern for what you're asking. So we generally are going to ask that you present questions or ask questions anonymously. If you have a question that arises during the town hall or during this presentation, please feel free to enter it into the Q&A, which is there on Zoom, and we'll take a look at it and select the option when you do enter a question to send it again anonymously, please. Related caveats. If you don't remember to click to send it anonymously, your question isn't going to be anonymous. So that is important. Please make sure to do it. Second, we had a bunch of questions before we even began today from registrants, and we expect to receive many more questions today, trying to leave the second half of today's presentation to answer as many of those questions as possible. But please understand, given the number of questions, we may not be able to get to everyone's question. We will, though, try to get to everything we can, and we believe your input's important. So please do add questions as they come up. Finally, I want to make sure that everyone is aware that the judges on this call who hear cases in court have certain ethical constraints that don't permit them to talk about specific cases in any court system. They can't talk about cases which are pending or which are anticipated to be pending in a court, and they can't take public positions on issues of politics. They are supposed to remain neutral as our arbiters. If there are questions an active judge can't answer on this call, we will have an attorney answer them, such as myself, or a judge who does not sit on assignment through the Judicial Council, someone like a retired judge, such as Judge Wick. All that said, and without further ado, I want to pass this off to our first speaker, Justice Brown.
Good afternoon, everyone, and thank you for being here today. I want to take just a few minutes to talk about something that affects all of us, how our government is structured and why it matters. Along the way, I'll share some historical examples to help us understand how this system shapes our lives, where we've been, and possibly where we're headed. So let's talk first about how we got where we are. In 1787, our founders gathered in Philadelphia with one critical challenge: how to design a government that resists tyranny. James Madison warned against placing too much power in the same hands. After all, the founders had just fought against King George's rule of absolute rule. They knew they needed a system of checks and balances, one that limited power but still allowed government to function effectively. And the solution was the separation of powers doctrine. At the time, the Articles of Confederation governed the United States, but the Articles were too weak to handle national crises. And that became clear during Shays' Rebellion in 1786, when angry farmers, armed literally with pitchforks, shovels, guns, and knives, stormed courthouses to protest economic hardship. And the federal government lacked the power to respond, which revealed the need for a stronger national structure. This crisis helped push the founders to draft the U.S. Constitution, which established 3 branches of government: legislative, executive, and judicial, each with specific responsibilities to balance power and maintain stability. So let's talk about those 3 branches, their roles and responsibilities. We'll start off first with the legislative branch, which represents the power of the people. The legislative branch makes laws and controls government funding. As I said, this is the people's branch. Its members, both in Congress and state legislatures, are directly elected to shape policies that reflect public interests. The founders prioritized this branch after experiencing King George's unchecked rule and the concept of taxation without representation. To prevent that from happening again, they placed lawmaking authority in the hands of elected representatives. The next branch we'll talk about is the executive branch. While Congress creates the laws, the executive branch enforces them. The president leads at the federal level, whereas governors lead at the state level. I compare the executive branch to quarterbacks. They don't make the rules, but they execute the game plan. And from the start, George Washington set key examples for executive power. Instead of ruling unilaterally, like King George, he created the cabinet system, regularly consulting advisors before making major decisions. And then looking forward to 1952, when President Truman issued an executive order seizing most of the nation's steel mills during the Korean War to prevent a strike, the Supreme Court in the Youngstown Steel case ruled against President Truman's exercise of executive power, reinforcing the principle that no president holds unchecked power, even in times of crisis. And that case set a precedent for limiting executive authority. The judicial branch, which I just referred to when we were talking about the Youngstown Steel case, let's talk about the judicial branch. While Congress makes the rules and the executive branch enforces them, the judicial branch interprets them and ensures that they align with the Constitution. In 1803, Chief Justice John Marshall established the principle of judicial review, the power to say what the law is and to declare laws unconstitutional, in a case called Marbury versus Madison. You can think of judges acting like referees, ensuring that the rules are followed and remain fair. When a law contradicts the Constitution, courts have the power to strike it down. And as a judge myself, I see this responsibility firsthand. A judge's role is not to create policy, but instead to apply the law impartially, even when decisions are unpopular or uncomfortable. And that's a safeguard. The law stands independent of political pressure. So, under the theory of the separation of powers and checks and balances, the idea is that separation of powers works because each branch holds the others accountable. And history has shown that when one branch overreaches, the others step in to restore balance. And one of the clearest examples of this principle is Watergate in 1974, when President Nixon tried to withhold incriminating tapes under the guise of executive privilege. The Supreme Court unanimously rejected his claim. Nixon had no choice. He surrendered the recordings, and soon after, he resigned. So that case proved that no one, not even a president, is above the law.
Thank you, Justice Brown. It takes me back to some pretty interesting civics classes and pieces that we've had in the past, but this is a really rich and timely topic, obviously, and the checks and balances. And we had a lot of questions about this before we even started, and we've had some flowing today. And I wanted to ask you a couple now, sort of before we move on to the next stage, and we can return again to some of these when we get to the Q&A. But one of the sort of most fundamental questions that we had in advance was, what power does a judge have over the President of the United States?
So it comes through the system of checks and balances referenced earlier, in the idea that litigation before judges, and frankly, it's most commonly in front of federal courts, as anyone reading the news today would notice. Litigation, usually in front of the federal court, might include the executive branch as the plaintiff or defendant. And the executive branch is bound by those rulings like any other litigant, with their remedy being the same, which is to follow the appellate process. So if a judge issues an order that one side or the other doesn't agree with, that litigant, whoever they may be, whether the president or, a single individual, can appeal the ruling to higher courts. And, any concern about whether a president will follow a court order then centers upon the notion of Congress's, and ultimately, I think, the voters' ability to hold the executive accountable through issuance of orders that require compliance by agencies, wherein disobedience could result in contempt of court consequences. And then again, as I said, the people demanding through their vote, and through even more, frequent contact, such as by contacting the representatives directly to urge them to hold the executive accountable to the court's ruling.
That checks and balances piece obviously incredibly important for what we're talking about today. And there was another sort of theme in some of the early questions about, the judiciary being like the check and balance in the Constitution, and how well that's working. And one of the sort of specific ones that I had in mind was a registrant that was asking if we have confidence that the Supreme Court and our California courts, to the extent that that is relevant, will stand up to the executive branch when there's talk constantly of sort of impeaching judges who contradict the policies of the executive. What does that mean, and what can we do about it?
Well, I mean, that's what the separation of powers and the idea of the rule of law, which other panelists will get into later on, are all about. And as folks may know, Chief Justice Roberts of the United States Supreme Court recently made comments about how inappropriate it is to call for the impeachment of judges when a judge issues a ruling that a person might disagree with. The remedy, as alluded to previously, is to take that decision up the chain through the normal appeals process. And folks might also recall a few years earlier, Chief Justice Roberts also commented that, there are no Obama judges or Biden judges or Trump judges or Bush judges. There are just judges. And regardless of our personal feelings or personal politics, our job is to apply the law impartially.
Yeah, I mean, it's a great analogy. We talked about the executive being sort of like the quarterback or the players on the team, right? If you don't like the call that the ref made, like, you can challenge, you can throw your protest flag and maybe lose a timeout, but have them do an immediate review of it. You take it up on appeal, but at the end of the day, the quarterback doesn't get to tell the ref, no, I'm just not going to listen to your ruling, right? It's a great system when it works right. I want to be conscious of time. I want to ask at least one more question. I think there are 2 or 3 more we'll probably return to in the Q&A, but another sort of broader question that was raised was how we can support an independent judiciary. You know, it's designed to be separate from the legislative and executive branches, but how do we support the judiciary being independent and keep it from becoming political?
I think that's a great question. And my hope is that by participating in things like this and by understanding the importance of separation of powers in our system and by supporting the unique role and importance of each branch, and in particular, the concept that the judiciary is intended to be independent, regardless of, the political views of the day and regardless of the views of, perhaps the majority of people. Our role is to apply the law impartially, even if we personally might disagree with it. And even if a person might individually disagree with one of our rulings, the hope is that by understanding the role of each branch of government and respecting that role, that people won't call for impeachment or voting out of office people willy-nilly on the basis of one decision that they might not personally agree with.
Yeah. Well, that's fantastic. Like I said, I think we've got some more questions. I just want to make sure we make time for the presentation. And I'm going to hand it off now, if that's okay, to our next presenter, Judge Thompson.
Good evening, everyone. I think the natural handoff from where Justice Brown left off in terms of how you, the viewers, can support an independent judiciary is really understanding why this matters. The system protects real rights and freedoms. The Civil Rights Act of 1964 is a really powerful example of how the system protects freedoms. Congress passed the law, President Johnson enforced the law, and the Supreme Court upheld the law. When the system functions as designed, meaningful change happens. I've seen this balance in my own courtroom. When I make decisions, I know a higher court may be asked to review them. That's not a challenge on my authority. It's a reminder that no one person holds absolute power. It's a safeguard ensuring that justice is not just done, but done right. Without these checks, too much power would be placed in the same hands, which is exactly what the founders wanted to prevent. Benjamin Franklin, when asked what type of government the founders created, famously responded, "A republic if you can keep it." His words underscore a truth. Democracy is not self-sustaining. It requires an engaged, informed public. We all play a role in keeping the system strong by voting, staying informed, holding leaders accountable. Understanding how our system works and our role within it helps ensure this experiment in self-government endures for generations to come. The rule of law, which is a term that we hear a lot recently, it refers to the fact that we are governed by laws, that all people in this country, regardless of who you are or what you do, must follow the law and are held accountable when you don't. It's the basis of our Constitution and critical to the functioning of our democracy. So why is it important? Consider our federal and state constitutions. These documents do two important things. They spell out the powers, the authority, and the limits of our government. And most importantly, they confirm the rights to which we are all entitled as free people. That recognition and affirmation of our rights and freedoms we enjoy comes with an understanding that there's a balance in exercising freedom with the need to let everyone do the same without being harmed or unreasonably infringed upon by someone else. This is how we function as a society. Law creates an expectation with our community about what's acceptable in what we do and what is not. And it tells us what happens if we do not act within the law. Think about driving, for instance. Consider the street markings, signs, and lights that guide us when we're behind the wheel. That's all done through law. So while we're entitled to go where we want, we're still required to follow those markings, signs, lights, and other rules of the road. Why do we do that? It makes sense. For us to enjoy that freedom to travel, we need to do it in a way that minimizes the risk to everyone else wanting to do the same thing. Imagine trying to get to work every day with no markings, no signs, no lights, especially in San Francisco. It would be chaos. Driving anywhere would look like something out of a Mad Max movie. And when we don't follow these rules, we get tickets for doing something wrong. Or in more serious situations, one might be arrested and charged with a crime. Accountability can also come through a lawsuit from causing harm or having financial consequences imposed upon someone for the damage they've caused. This is how the rule of law works. It lets people know what the rules are and the method of accountability when they're broken. As it relates to judges, another good example follows exactly what my colleague Justice Brown mentioned in that sports example. Imagine a situation in which a referee calls a foul. The rules tell us whether the actions are fair or foul. The referee or umpire is tasked with making that decision. But if the referee decided not to follow the rule by either not calling a foul or calling one when it didn't occur, we can be confused about how to play the game, or worse, not trust that the game was fair. These are the things that we contemplated when we declared independence from England and formed the basis of our Constitution. In adopting our Constitution in 1789 and in California in 1879, we committed ourselves to the rule of law. And in doing that, we affirm that it applies to everyone. An important component of the rule of law is the right to be heard. This falls into the broader concept of what's called due process. Due process incorporates rules about how we're to be notified about an action against us, what court and community is appropriate to hear that action, and what we're entitled to once we are within the legal process before a hearing or after a hearing. This means that we have a right to be heard before a judge, and in some instances, a jury, as well as a right not to testify in criminal matters without it being held against us. The job of a judge or a judicial officer, because we have commissioners and we have others who act as judicial officers, that role is to serve as a neutral person that looks at facts and law and determines if those involved in the case acted within the law or whether they did not. When we do so, we do it without prejudice. That means that we don't judge them based on anything other than the evidence presented to us, and not until we've considered all the evidence. This idea includes those occasions when someone is suing a state agency or when one might question the constitutionality of a law. As Justice Brown mentioned, we're an independent third branch of government, and we're not aligned with any government actors or agencies. It's our job to decide whether the state agency or actor is wrong, or whether the law being challenged is constitutional, meaning does the law in question comply with what the constitutions of both the state of California and the United States permit. We're the ones explicitly authorized to make that determination. So, who are your judges? Judges in California are either appointed by the governor or elected by voters. We hold our positions in the Superior Court at the trial court level for 6 years. Appellate court justices serve for 12 years. We must run for re-election to remain a judge or a justice. If a judge leaves their position early or at the end of their term, that results in what's called an open seat, and attorneys can seek election to that judicial office. Every state judicial officer takes an oath to faithfully uphold the Constitution of the United States and the Constitution of the state of California. Only lawyers with 10 years of experience are eligible to become a judge in California. For judges who are appointed, the vetting process is rigorous. There's an application with over 70 questions, there are background checks, in-depth description of cases that go into that application, of all the cases that we worked on, including references to opponents with whom we had those cases, were reviewed by people we worked with and against, including judges and attorneys who are familiar with our work. And we receive ratings from the Judicial Nominations Evaluation Committee that is appointed by the state bar. Keep in mind that to be a lawyer, we typically have had over at least 7 years of combined college and postgraduate education. Once we become a judge, the learning doesn't stop. There's a steep learning curve, as I can express from recent experience, to get up to speed to know what it means to be a judge, even if you do have extensive experience being a lawyer. We get extensive experience and training and how we do our jobs and how we're supposed to do our jobs, with weeks devoted to specialty areas of law, whether it's traffic or criminal or family law or probate. It really depends on where we're assigned. But we're also provided education in other specific areas that help us learn how to listen as judges, not as advocates, and how we can respond and how we can maintain our courtrooms in a way that are trauma-free and that are sensitive to racial issues and community dynamics. We have requirements that we also update our training and education often so we remain fresh and up to date on the substantive law, as well as new developments that may affect our ability to be effective as judicial officers. Being a judge requires an ability to quickly grasp areas of law in which we might not have been familiar in our previous careers. The state provides a great deal of resources and conferences to ensure that we're well educated in the areas in which we're assigned and to ensure that we remain up to date on changes in the law. One important thing we do in supporting the rule of law and encouraging the same thing in our communities is to explain our decisions. That means telling the parties and those who are interested in the proceedings why we decided the way we did or made the orders that we issued. We describe the facts we relied upon and the law that we followed in coming to our decision. This tells those in front of us that they were listened to, even if they don't agree with the ruling. Explaining our decisions helps us too, because it focuses us on the correct law and what was argued. It also provides a roadmap for the appellate courts so they may determine if we got it right. Any litigant who feels a judge made a mistake in applying the law or how it interpreted the evidence can appeal that decision. Using our sports analogy, this is the equivalent of sending it up to the booth for review. In our case, it's normally not an instant replay though. The litigants get a second chance for review with the possibility that the trial court's decision will be overturned through a thorough appellate review process.
Thank you, Judge Thompson. You know, it is a reminder, it's not an instant replay, right? This is a process. We've got the appeals, we worked through it. I think we're gonna have some questions about that in the Q&A about sort of what do you do if you don't like the decisions, or how do you adjust that process? And we'll get to that, but I'll just remind everybody here, you vote, right? We've got a democratic system. You don't like what's working, you vote to make change. But a lot of the questions we got in advance for this dealt with the concerns about the neutrality of judges and their experience and their training. And so I want to address a couple of those, and we may save some for later. But one of the most sort of basic questions we got was, what do you do if you see a judge on the bench who is clearly exhibiting bias? How can you address that? Who do you say something to?
Well, there are a number of ways that can be addressed. One way is that under state law, you have a right to indicate that you believe a judge is biased and you can challenge that judge. That's something that is not subject to challenge by that individual judge unless there is some reason that that motion hasn't been timely made. But it doesn't stop there. In this courthouse, we are governed by a presiding judge, and that exists in all of the counties in the state of California. A complaint can be made to the presiding judge to point out any concerns that a member of the public has about any judicial officer who sits in that court. Once a complaint is provided to the presiding judge has a duty to investigate a complaint, to really explore whether or not there's merit to it, and to respond to anyone who made that complaint. The third way is that judges are evaluated and can be reviewed by what's called the Commission on Judicial Performance. So complaints may be made either informally or more formally, whether it's clicking in sending an email or sending a letter to the commission for an evaluation. They have a staff, an executive director, who evaluate the merits of that complaint. They decide whether or not to initiate any investigation. And if they do conduct an investigation, there are a number of different things that are available to them to allow them to help remedy the issue. It can range from either responding to the judge to tell the judge that they did something wrong privately, to do so publicly, to encourage the judge to get additional training, or to do anything to the point of a public censure or even removal of the judge if their conduct is really egregious.
You know, it's interesting too, you touched on this with the background and the vetting of judges, but also, of course, if you've got practitioners, attorneys, or other judges that are working regularly with the judge or an elected judicial official, they're going to have a comment stage, right? When you're evaluating someone to be a judge, there's a piece in there. So it's part of that sort of almost voting process for those in the profession. Contrast to that, and this was one of the questions we got, if you're a member of the public, and so maybe you've never, hopefully never appeared before the judge before. It's the first time that you're having interaction with the judge, and you're being asked to vote. Do I vote for this judge or not? How does a member of the public, how do our fellow citizens get information on a judge running for office or for one of these elected judicial positions? And how can they make an informed decision about who to vote for?
Well, there are numerous ways they can do it, but I have to acknowledge that judges are way down on the ballot. And because judges are way down on the ballot, many people just gloss over by the point they get there because they're like, I don't know who these people are. So one of the things to consider is that people who have been appointed have gone through an extensive vetting process. That's one thing to take into consideration. The second thing, though, is that in San Francisco, for example, the Bar Association of San Francisco provides a service to voters by doing its own evaluation of anyone who is on the ballot for an election. And they do an independent vetting of any candidate who appears on the ballot. So that's something in San Francisco that's available so they can evaluate it. It's also the case that newspapers, editorial boards, and independent groups like the League of Women Voters and other organizations will do interviews with candidates and provide information to the public. Sometimes they provide just biographical information. Sometimes they ask a number of questions about their background, their experience, and they provide information that's supposed to help the public sift through and make an assessment of who these people are who may appear on the ballot, way down the ballot, which is beyond where many people normally consider they have the ability to really discern what the issues are. One of the challenges is that because of the nature of our role, as judges are not supposed to be committing to positions. And so it's really important to consider some of those neutral sources to arm yourself with more information about who these people are and what their training and experience consist of as you're making an assessment as to who the people are who you are being asked to decide whether to return to office or to elect to that office for the first time.
Yeah, I mean, there's a really interesting dichotomy here in that, as you explained it, the judge, in your order, in your opinion, that's where you're sort of explaining yourself and you're giving, this is the basis and why I made the ruling. Once that's done, that's sort of it, right? I mean, you're not going to get the opportunity. You're not supposed to take the political decisions. You're not going to be able to express beyond the four corners of that piece of paper what happened. And a lot of the public may not be seeing those orders. They may not be reading all your orders before they vote for you. So these sources of information are really invaluable. And as you pointed out, that there are lots of them, and people should read them and be informed. It's a great resource. I would say the other broad category of questions that we got in advance, and we'll ask one or two of these, but I may punt some to the Q&A session, had to do with some of the biases and issues that we all carry as people, and judges as fellow citizens and human beings are coming from their perspectives where they are neutral arbiters, and they are attempting to adjudicate the rules in a neutral basis, but people have concerns. And you talked about some training, and I want to talk some more about that. One of the questions that we got was discussions that scholarship and articles about systemic racism and violence and how that's invaded the U.S. justice system. How can we generally open up the courts to concerns about systemic racism and violence in the system?
In our training in California, we do acknowledge systemic racism and that history. The one of the things to consider, especially like in the criminal courts, for example, there are now jury instructions that relate to explicit bias and implicit bias. And that's something that was pushed by the California Judges Association to ensure that we could elevate those issues. Judges serve in a role where people come into our courtrooms and expect to be treated respectfully and fairly, regardless of who they are. It could be someone who is a victim. It could be a criminal defendant. It can be lawyers. It can be a parent. It could be a member of the public. There are a number of different people who come in, and many of those people are in this situation not because they want to be there. So a lot of the education that we get about being a judge focuses on heightened awareness around that key aspect of our role. Understand that people are coming in and you need to understand and appreciate accepting them from the vantage point they're entering into our realm, where as lawyers, people recognize what they do and they come armed with their briefcases or their laptops and things like that. But many of the people who find themselves in the courtroom are not prepared with those armaments. They're not trained in that way. And I found that one of the really important things in judicial education that we have in California is to help us recognize that the people we're reaching and the people we're talking to and the audience before us and the people we're serving is much broader than just those lawyers who come knowing what the dynamics and expectations are. And I think all of that type of education helps guide us in looking at things like systemic racism, implicit and explicit bias, and trying to create environments that are not going to compound traumas that people previously experienced that may have resulted in the incident that is being adjudicated before us.
I want to make sure we make time for Judge Wick, but there's one question that I just want to spin off of there. And you were talking about some of the trauma, and this was an interesting question we got in advance. The focus of this was about one of the participants raising concerns about survivors of domestic violence being seen and heard in court, and particularly in situations where they come to court in family court and their abuser just provides a false narrative and they're forced to sort of relive all this and fight. The questions were, both how can you make sure that those sorts of survivors get a judge to see through the false narrative and avoid attributing that this abuse claim is just some sort of he said, she said, I've got a narrative on this side, narrative on that side, and sort of devalues the victim. Also, how can, and this is, I think, the part I really want to get into with you as well, is how can, survivors or lawyers raise these issues? How can they get research, including about this bias that maybe people aren't thinking about? Racial bias maybe is already on the radar, but maybe abuse for a survivor isn't on the radar. How do you get that in front of a judge without the judge feeling attacked or defensive? And sort of more broadly, how can the public engage constructively with the judiciary to say, hey, I'm concerned that maybe you don't get the point of view that I have, and I want to have a neutral arbiter, and I want you to see this piece. So kind of a big question there, but I think it very much speaks to what you were saying, and I'd love to hear your input on it.
Well, there are a couple of things. One, I want to provide some reassurance that when judges get new assignments, so if you're assigned to domestic violence, there's mandatory training.
Mm.
One of the reasons there's mandatory training is there's a recognition that if you are focused on these types of issues, you really need to have a deeper understanding of these specific types of issues. So that I want to offer as a point of reinforcement. If one finds themselves before a judge who hasn't had that training, there are ways where you can offer perspective, whether it's articles or whether it's information about this type of issue. Many judges are receptive to information, whether that is presented in submissions to the court, where that submission is made by the person who's a litigant about additional information. That information, if it's in a contested proceeding, has to be shared with the other side. But there are ways to provide to educate judges lawyers are used to educating judges, but being in a position to help inform the judge and elevate the judge's understanding of an issue, because many of the people who become judges in part because we're interested in learning new things. And so recognize that you may hopefully have an audience that is receptive to the new information that's being provided.
Yeah, I mean, just going to the point that judges are some of our best, the amount of experience, amount of training, really, it hits home. These are folks that want to learn and want to get it right and are dedicating their life to public service. So with that little plug aside, I want to make sure we move on to Judge Wick, because I know he's got an important part to cover for us as well.
Well, thank you. Good afternoon, one and all, again, and thank you for joining us here in our conversation today about the judicial branch and other aspects of what we're discussing here. One of the aspects I wanted to touch on is California judges are obligated to follow the canons of judicial ethics. Those canons were adopted by the California Supreme Court in 1996. Those canons guide our behavior as judges in and out of the courtroom, as well as in our private and public lives. They are keys to ensuring actual fairness in the work we do, as the continued appearance of fairness, both of which enhance trust in the integrity and decisions of the judicial branch. We're required to be faithful to the law, regardless of partisan interests, public opinion, or criticism. Judges cannot hear cases if they can't be fair to one side or the other, and we should not hear cases in which it appears that we are not able to fairly judge. Think of the situation in which a family member, a friend, or a campaign donor was in front of the judge. Does anyone think that that situation would appear to be fair? I think not. We're not going to prejudge cases, and we're not allowed to do so, meaning we don't decide what the facts are until the evidence has been presented or shown to us. Judges cannot state their opinions on matters they have heard or may hear. They can only do so while deciding the case, either in court or as a part of a written decision. We are forbidden to accept gifts. Why is that? It may cause someone to question a judge's impartiality. The obvious example is if one litigant tries to give the judge a gift. But what about the situation in which a law firm, with no current case in front of the judge, offers a gift? What message might that convey if and when that firm does have a case in front of the judge? We're restricted from offering any public comment or opinion on anything other than that which surrounds the administration of justice. And those comments are narrowed so that what affects the improvement or the administration of justice, we are allowed to comment upon, just like we're doing here today. Judges who do not follow the canons of ethics can be referred by anyone to the Commission on Judicial Performance. This is the executive branch's check on the judiciary. Lapses in following our ethical obligations can lead to private or public discipline and even, as stated earlier, removal from office. Now, what does this mean? In our rulings and decisions, we judges cannot in any way consider the following: politics, including anyone's political affiliation; public opinion; the, quote, will of the voters, unquote; or someone's connections, wealth, or poverty status. Those things are not to be considered by the court. This is different than legislators and members of the executive branch who are elected to represent the ideas and ideals of those who elected them. Judges, whether appointed or elected, must commit themselves exclusively to reviewing and applying the law fairly and evenly based on how the law is written and the facts of each case, regardless of our personal or political preferences. In the traditional way we think of politics and the way we are used to seeing it exercised in the creation and enforcement of the law, the intersection of law and politics is not in the courtroom. This is not to say that we never have a case having to do with an election or a controversial matter of public interest, which has political overtones to it. Those cases do come before us, but neither the political outcome nor the party of any individual involved in the case is a proper basis for a decision. We are not legislators or executive branch members. We cannot participate in political activity, publicly support political causes, attend political fundraisers, or make comments about people seeking political office. However, there is an exception. Judges may participate in judicial election campaigns. We can appear at fundraisers, give and receive money, and publicly support or oppose contenders for judicial office during an election. This is the only exception for us. Generally, we are not allowed to speak publicly about any case, whether it's before us or before another judge, that is pending, that may be on appeal, or may go up on appeal in any court. Except during a judicial election, our canons do allow us to discuss cases for which we were or another judge may have been criticized or challenged. All of our courtrooms, with the exception of juvenile court proceedings, are open to the public and everyone is welcome. Judges would love to be able to provide the transcripts of all of our hearings that would help explain our decisions, but unfortunately, that simply is not feasible. Because not every courtroom has a court reporter. Court reporters are entitled to be entitled to be paid for every transcript they produce, and transcripts can literally take weeks to prepare. If you've ever witnessed a time when a judge was under heavy criticism for a ruling they made, and you wondered why you never heard from them, please know that we are not permitted to speak pursuant to our canons of judicial ethics. Remember, we were lawyers once, so we would definitely like to talk and explain ourselves if we were permitted. We simply are not. So, returning to our Constitution for a moment, the judicial branch bears the responsibility for preventing the other two branches of government overreach. A courtroom is where all individuals with legal grievances can be heard, no matter who they are. Everyone cannot leave with all the things they wanted from a particular dispute. However, everyone can and should be heard and should be treated with respect. Judges are required to fairly and equally administer the laws to all persons, regardless of age, ethnicity, race, gender, disability, religion, or social status. They must not be influenced by public opinion. As Supreme Court Justice Robert Jackson wrote, the very purpose of a Bill of Rights was to withdraw certain subjects from political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. That doesn't mean we don't have opinions. It means our opinions must take a back seat to the rule of law. The point of all is to ensure a peaceful means of resolving all of the disputes brought into our courtrooms. I'm going to give you a few recent examples highlighting the dangers of attacks on the independence of a judiciary as a co-equal branch of the government. Since 2015, Poland's ruling Law and Justice Party has enacted legislation designed to strip judges of their ability to provide checks on the executive and legislative branches. That party has refused to recognize judges appointed by the prior regime and has replaced them with their own appointees. That party enacted what is known as a muzzle law and empowered a disciplinary body and has brought proceedings against judges for questioning the ruling party's platform, including firing judges or cutting their salaries for speaking out against legislation aimed at the judiciary, or for questioning the legitimacy of new judicial appointees. In the last 8 years, over 1,000 Polish judges have been targeted by the disciplinary chamber. What this leads to is loyalty to the political party instead of loyalty to the rule of law. Like our baseball and basketball and football analogies, it would be akin to a referee or umpire making calls in favor of one of the teams or players they like instead of based upon the rules of the game. And this would be simply unacceptable here in California and here in the United States under our tripartite government. I should point out that in the United States recently, and frankly in South Dakota, an initiative was put forward that would allow judges to be sued or sent to jail when people disagreed with their decisions. Would umpires or referees do their job fairly if the fans could throw them in jail for unpopular but correct decisions? In 2015, a Sacramento judge decided that civil unions between same-sex partners were allowable according to the Constitution. A special interest group mounted a recall campaign within 24 hours. For that single decision alone, higher court justices were also threatened with recall as well. Would it be fair if umpires were fired by fans for unpopular decisions that actually followed the rules? In San Francisco, a group of lawyers challenged 4 judges who were all appointed by a particular Republican governor. It should not matter, though it happened to be true, that none of the challenged judges were Republicans. 2 years ago, also in San Francisco, a group of lawyers challenged 2 judges who followed the law and their canons of judicial ethics, but who the challengers attacked for political reasons alone. In New Jersey, a federal court judge's son and husband were both shot by an angry attorney who had rulings made against him by the judge. Similar things have also happened here in California, unfortunately, from unhappy or disgruntled litigants. Should we expect anyone to pay with their lives, those of their family or friends, for simply following the rule of law? If we can't safely do our jobs, we can't work in your service and protection. Former Justice Sandra Day O'Connor once said, "We must be ever vigilant against those who would strong arm the judiciary into adopting their preferred policies." The Constitution founders realized that there must be some place where being right is more important than being popular or powerful, and where fairness is superior to strength. In our country, that place is the courtroom.
Thank you, Judge Wick. I
Thank
just
you.
want to remind everyone that while we're not talking about the federal judicial branch as much as the California judicial branch, but as Judge Apollo had mentioned at the beginning here, there are strong parallels among these. And looking at the states and these international examples, it's all clearly there. It's also interesting that you as a retired judge are more free to make these sorts of statements and say these things because respecting the canons and playing by the rules, our judges are not able to make certain political statements. And so definitely appreciate you being here and giving voice to some of these concerns, obvious ones. There are a couple questions that we've had, and I want to hit on some of them, but one of the most fundamental ones that we had was a question of whether neutrality is even possible when judges are under attack. I mean, how does someone who is being attacked in this way but can't speak out, how do they maintain that neutrality?
Well, we are absolutely required to do so.
Mm.
And the neutrality is an absolute must. A judge, a sitting judge cannot be seen as an advocate for any particular position. And it's uh, terribly important that people understand that. So there have, and we've all seen judges who have been under attack for making what they thought was the best call under the circumstances. And for another judge then to speak out for or against that would indicate a lack of neutrality. And is it difficult? Yes. It is. Is it impossible? It is not.
Mm.
And judges are required to remain neutral or remove themselves from the case or the situation in its entirety. And it's not difficult to imagine those scenarios, but it is difficult to sit quietly while someone is haranguing you or a friend or colleague of yours for what you believe is inappropriate. But there are other ways to address the situation than from the bench as a sitting judge.
So to those other ways and to that challenge where you have to sit quietly, how do judges balance upholding the law while responding to these shifts in public opinion and political pressures?
Well, you you do so by maintaining. Uh, it, I have judge friends and justices who have their oath of office sitting in front of them. We swore to do our best under all circumstances, not most, not some, not those we favor or don't favor, but all circumstances. And it's so critically important. And I always thought it as an educational opportunity. I had people in my courtroom stand up and question, Judge, why are you allowing this to happen? And you can address those people in your courtroom and you may educate individuals, but you must remain neutral and remember we're guided by the rule of law.
Yeah. Any special tricks that you've used to help tune out some of that noise when you hear all these political pressures outside? It's looking back at the cannon on your desk or.
Focus.
Yeah.
I maintain focus. I remember the promise I made to myself. And that promise not only affects me, it affects those people in my courtroom and those people outside of the courtroom. And I want them to understand you have a judge that's willing to take the heat, so to speak, and stick to, adhere to the rule of law. And I think, as Judge Thompson pointed out, one of the best ways to address that is to do it calmly in your decision before the court and provide your rationale. Now, sometimes, unfortunately, you might get younger judges who are hesitant about giving all of their rationale on the record. I think it is a wonderful way to tell the parties, meaning the litigants, the attorneys, the press, and those people outside your courtroom, yes, despite what you saw here today, I'm going to remain neutral and I'm going to make a decision based upon the following evidence. And these are the rules of law which I'm applying to the situation.
An interesting riff on that theme, which was a question from one of our registrants about how you think the state court bench should respond to written orders by federal district court judges that perhaps directly criticize the specific state court judge or make a political style argument. So you're dealing with maybe something that's a little more political that's being pushed back to you from another judge. What's the best way to deal with that?
Remain neutral, adhere,
Yeah.
adhere to the point of law being raised, recite why you're not going to get involved in the fray in this political situation. And many judges are called on to make political type decisions. The state of California is being sued, a county, a governmental official is being sued. That doesn't mean we've left our position on the bench to make these determinations. We adhere to what we've promised to the public, to our training and experiences on the bench, and you make a decision according to that guiding principle, the rule of law.
So I've got two more questions I want to ask you specifically, and then I'm going to kind of open it up to Judge Thompson and to you on some of these Q&A questions that we had. But the last two, and they're sort of linked. One was, how do judges balance public engagements with ethical restrictions that they have? And somewhat related, what, as a judicial officer, are your best practices for remaining neutral in the face of local politics? I think you hinted at a couple along the way, but it's a nice way to kind of sum up, how do you balance
Right,
it,
right.
and what do you do to stay neutral?
Well, I think you balance it. You certainly should be selective as to where you appear in public, because I, like many other judges, used to appear in public for a variety of reasons. One was to show my support for the independence of the different branches of government. I
Mhm.
enjoyed city council meetings or county board of supervisor meetings or that sort of thing. Uh, but I'm not there to influence people or provide my opinion on a topic. After all, when that body makes a decision, that decision may be coming to me for a review. And so you must remain neutral and impartial. And I'm sure every judge hearing this has had to make a decision that they did not necessarily agree with. Not factually, not legally, but gee, if I was an independent person out there, a member of the public, I would look at this differently. Well, I'm not sitting on that bench in that robe as an independent member of the public. I'm there to judge the facts based on the law and the evidence presented in the courtroom, not something I surmise from how I think it should have gone. And I think we as judges almost weekly, if not daily at times, would go through the analysis saying, stay out of the fray, maintain your demeanor, exercise your authority in the proper way, and provide those in front of you with a reason for your decision. That doesn't mean everybody's going to agree. And in fact, almost every case has a loser and a winner. Not always, but you don't champion one side over the other, or or I think that's the best way to approach it. Now, Judge Thompson might feel otherwise.
So, we'll have Judge Thompson sort of join in here, because I think definitely some comments on this, and I do have a handful of Q&A questions that sort of cross topics, but I would be interested to hear your sort of view on maintaining neutrality, particularly when you're under pressure and you've got these public engagements or you've got political headwinds that you're facing.
Here's the form way of thinking about it.
Yeah.
We're not supposed to have a dog in the fight. And if you recognize that's the nature of the role, it makes it easier to have distance to try to say, what are the facts? What's the law? Here's the decision I've come up with. And to exclude a lot of the noise that may be surrounding the specific decision that's in front of you. Sometimes members of the public get frustrated with judges for not doing more. And one of the reasons they get frustrated is that they are concerned that, well, you focused on this one case and this one incident or these facts in this jurisdiction on this issue, but the broader, bigger concern, it's so much more important. It's not to suggest that the broader concern isn't important. Our role is to try to stay in our lane and to be tailoring our response to meet the need of what's called a live case and controversy that's presented before us, and try to ensure that the decision that we're making addresses that specific controversy. There may be broader things and broader implications and ripple effects, and we may be able to point to what some of those issues and implications might be, but a holding or a decision should focus on that ripe controversy. And I understand that can be frustrating a lot of the time. It can seem limiting a lot of the time, but on the other side, you could say, oh, we can appreciate that they understand that they're addressing the crux of the question that's been presented. And that's the focus of the inquiry. I think that's one way to keep our focus on the issue instead of being swayed by or influenced by the outside noise.
I can say I've had in large political controversies that enter the courtroom, and on occasion I've allowed the public to speak because they're not going to remain silent. So I'm not making a record, so to speak, but I'm allowing the public to understand. And then I turn to the attorneys who are presenting the sides, and I say, based upon all the input received, do any of you wish to raise new issues of concern for this court to decide? Or do you have issues which you feel need to be addressed? I'm not asking for your vote, counsel. I'm asking if you want to frame an issue for this court's decision, now would be the time to do it. And I didn't mind that, especially in some of the larger cases. There are cases in which you have 300 or 400 parties. Everyone's not going to get a chance to speak. And that's frustrating. And so I found that allowing some of that input so that the attorneys could focus their comments so that they could get a response from the court to address particular issues was helpful.
Well,
And it gives
and sometimes those comments are absolutely appropriate, and sometimes they're required. So in the context, California has a Marsy's law that says that victims have an opportunity to be heard. And that is one component of where people can come forward and voice their concerns about the effects of something that happened to them or a family member, or in making custodial decisions, we may sometimes consider the effect on someone where you're evaluating their custody. Feedback from people in their family who say that will be evicted as a factor to consider in evaluating whether there's a less restrictive alternative or this is the appropriate thing to do.
Yes,
Yeah,
very much so.
part of being heard is being told you have a space to be heard, right? And then the framing has to be done within the rules. So I want to pivot a little bit now to a couple of these questions that we've had in the Q&A and that we didn't get to before. And one of them, sort of starting at a more specific level, was a question about whether the state judicial system can override policies by the federal executive branch. And the example was given is if mifepristone was federally disallowed, is the state judicial system able to do anything about that? Kind of a specific example, but I think it'll lead nicely into a couple of these other questions we've had about the broader ability of the judicial branch to affect. So what are your thoughts on that?
Well, as a sitting judge, I can't answer that question, so I defer to Judge Wick.
When receiving questions such as this, very broad, they're searching for the judge's opinion on given topics, which I think is highly improper. And judges aren't there to provide opinions as to what they think the facts or the law should be, or to provide guidance for how you take your particular situation, whatever that might be, and how that you bring it before the court. But I have indicated on occasion, you think that the situation is ripe for controversy, then you can bring it before a court for a formal opinion as to that particular issue. But we cannot and should not have judges who just are out as judges or members of the public offering their opinions on topics over which they have or should have no input, because we're not sounding boards for particular issues. Gee, Judge, how do you feel about Marsy's law? Or how do you feel about X, Y, or Z? And unless it touched in my courtroom on a particular case, and I might make a comment to one of the one of the parties or one of the attorneys, if you want to bring that before the court for a decision that it needs to be ripe, in other words, put in proper format. And if you think the issue is already ripe, you can tell me why, and I can touch on that ripeness, if you will, and I can touch on those topics in my decision, which will either be made orally from the bench, so you know where I am on a particular case, or in my written decision. And one of the things I liked about inquiry is I could tell the public, because my written decisions were published, I could tell the public there were 4 other issues raised. The judge cannot comment on these 3, but on one of those, the following. I denied the request because. And then you at least have a, a framework. The judge heard it, understood it. He might disagree with me, but at least this particular judge was willing to talk about the topic. And I think sometimes that's all they're wondering. Did you hear me, Judge? And you know where it was most common was in a criminal courtroom. The stakes are very high. People are charged in my felony courtroom with very serious crimes. And I wanted the parties at the table who had the most to lose, so to speak, to understand I'm listening to all of the evidence and I'm trying to make a decision based on the evidence and the law, not how I would vote on a given issue, not my feelings about a topic, but I will work something into a written decision so you understand I heard it.
And again, this is, a great example of what we've been talking about, that, when it's in the court and it's before me in my court and the evidence presented, you're going to get my opinion, and it's going to tell you why I ruled the way you did and why I interpreted the rules and the facts in this way. And that's the piece. But outside of that, it's not only wouldn't be appropriate, but it's not permitted for me to be giving you those sorts of opinions. And so it's, bringing it back full circle. We had a very interesting question during the Q&A, which is even a more sort of detailed piece, somewhat related to this. And that question was if an executive order is issued that seems to be a clear violation of both the sort of the basis and scope for an executive order, who has the standing to bring an action for declaratory relief or some change? And does it have to be a state or federal Justice Department or a state attorney general, or can it be Jane Q. Public, a member of the public who wants to step forward? This is in the weeds a little bit. It's more of a nice question, but it's a really interesting one given, sort of the state of our times.
Right. And very timely question, but so broad and so general, almost impossible to address. Because it really depends on who the affected parties are and that sort of thing. And I'm afraid, especially on the federal level, it's very hard for a state court judge. I don't think Judge Thompson's going to weigh in on this topic, especially for a sitting judge to start offering opinions as to what they think or feel about a given situation. I know that sometimes I would get the arguments in court that were in tune with politics, and those politics could be right out on the courthouse lawn. You have people out there picketing, and I would explain very calmly, I'm not interested in politics. I'm interested in evidence and the law that touches on those topics. So let's bring it back here into the courtroom and we'll talk.
So on the broader sense, sorry, Judge Thompson, I mean, if you've got a sense about the standing question, happy to have it, but I don't want to pull you into a morass here that is improper. So
Morass avoided.
excellent. So the really almost a fundamental question that underlaid that, and that I think underpins some of the other questions we had is what is the power of the judiciary to enforce its orders against the executive branch of the government, whether it's the governor's office in San Francisco, in California, or the federal level we're not going to touch on. But what are the levers and the mechanism that the rule of law permits for us to have to enforce orders?
Judge Thompson?
Mm-hmm.
Well, here's my sense of the question. My sense of the question is, what happens if someone ignores your orders?
Yeah.
I think I think it's helpful that in this entire exercise, we talked about the system of checks and balances. It is important that actors who swear oaths will fulfill those oaths because the system that we have really depends on the willingness of those who swear an oath to, when called upon to do so, exercise the courage to actually do the thing that they committed to do in the public interest. Courts rely on that in issuing any order to ensure that it is acted upon. And in the context in California, for example, in terms of executive powers and acting on orders of courts, sheriffs are independently elected in all the counties, and they are accountable to the voters, and they are the people who would go out and choose to enforce a bench warrant. That's a county function. It's an independent function where they are separately elected, and we do repose confidence in them that they will actually go out and execute on our orders, such as bench warrants, recognizing that they play a role that's a different role, but it's an executive role where we rely on them. So I provide that as an example of where we rely on the executive, and there's an independent chain of authority that's accountable to the public for the role that they serve in our communities.
There was, sorry, Judge Wick.
Oh, I was just going to touch on, of course, we have the power of contempt. It's to be used sparingly. People think that's kind of, gee, Judge, you can do anything. Well, not actually. And but you do have the power of contempt to bring people before you on a bench warrant or otherwise, and you do have the power to say, okay, I can impose a fine or even a jail term for certain conduct. In my experience over the years, the vast majority of people, once you reminded them of your authority, you didn't have to exercise it. Most said, I didn't realize I was stepping outside the bounds.
Yeah. So I want to throw this one out there, not for you to answer, because this is absolutely not the sort of thing I think that would be appropriate, but more because it takes us back full circle civics on this. And, you know, one of the questions in the Q&A was sort of about this and using the enforcement mechanism, or if, for example, a president does not obey a law. Obviously, you've got impeachment as an avenue to try to address that. But if you've got a legislative branch that perhaps is not aligned such a way that they're going to rule on sort of impeachment, what's the recourse? How do people address that? You've got a judiciary attempting to make a check. One of the other branches, the legislative branch, isn't participating for impeachment to address perhaps a contempt or some other order that's been issued to the executive, and the executive won't comply. And the question was, well, what do you do? Is this a constitutional crisis? What's the resolution? And I'm not a judge, so I can say something about this. And what I would say is you vote. Remember our civics classes. You don't like what happened. You think that the legislative branch wasn't doing what they were supposed to do to impeach or to help enforce the judiciary. Vote. Go out in the next election and change those representatives. So I think that there's hope. There are answers there. I can say it free and clear because I'm not on the bench. But you know, there is a piece there for us all. We are almost up against time at this point. You've given us wonderful answers. I've tried to hit most of the Q&A and what we've got out there. Really appreciate your time. We appreciate all the questions from our audience. Thank you all for participating in the town hall. It's a great and important dialogue, and one that should not end here. We should continue to talk. You know, we have 3 branches of government. We get a lot of attention in the nightly news to the executive, a lot of attention to the legislative branch. We don't get a lot of attention for our judicial branch. And when we need it, boy, do we need it. And you're seeing it right now. So thank you all very much for participating. Judge Ampalu, I don't know if you have any closing comments for us as well.
Thank you, Oliver. I do. And I just want to thank all of our participants today. What an excellent job. What a fantastic town hall. Thank you, Judge Wick. Thank you, Judge Thompson, Oliver, and also for Justice Tracy Brown. It was fantastic. I do want to answer one question that I don't think anyone answered yet, which is a great one. And the question says, we are seeing politics destroy the independence of the judiciary. How do we stop it? And I think my answer to that is exactly what we did here today. We stop it by educating ourselves about what courts do, what the public wants. Why is the system set up the way that it's set up? And why is it important that it's going, that it's set up the way it is? That's the first step. And the next step is that we have to value that. We need to take it to heart that this is for us and our communities. And then the third thing we have to do is if we don't like it, we have to speak up and say something about it. If we value it, but don't stand up when it counts, it doesn't have the same kind of effect. So, again, politics doesn't have to destroy our institutions. And there is something that we can do. So thank you for participating and being a part of this conversation tonight, everyone. Have a wonderful evening.
Good night, everyone. Thank you.
Thank
Bye-bye.
you. Thank you all.